Welcome back to this final segment of consideration. And in the last segment, of course, we went into some depth about Williams and Ruffy Brothers. In this segment, of course, we'll finish off by looking at part payment of a debt. And as I said, we'll also look at promissory estoppel. These are both areas, of course, which come within the context of consideration, because legitimately you could, on an exam paper, for example, see a question whereby on the one hand you have two issues where on the one hand you have to discuss a Williams and Ruffy type situation where there's a pre-existing duty operating, and in the other you see a request in respect of a part payment of a debt and somebody seeking to avoid it. So then, what if you owe me money and you decide to pay me part of the money, and in making that part payment, it is your intention to extinguish the entirety of the debt? Now, let's say you owe me £100 and I'm really desperate and you know it, and you come to me and you say, well, I know I owe you the £100, but will you take 50? And I said, yes, I'll take it. I'm so broke. And I take the £50 from you, and then a week later, you realize that I am suing you for the balance of the £50. Now then, you might turn on and say, well, hang on, she agreed to take the £50 on the basis that that was it. Well, what does the law have to say about it? We'll start off with this. The basic rule is that payment of a smaller sum will never discharge the duty to pay the higher sum. So the fact you've paid me 50, even if I promise you that I would not bring an action against you for the £100, that will not matter. It does not operate to discharge your duty to pay me the full £100. Case, of course, is Pinnell's case, and the rule in Pinnell's case is that the payment of a lesser sum on the day in satisfaction of a greater sum cannot be any satisfaction for the whole, because it appears to the judges by no possibility a lesser sum can ever satisfy the full amount that you owe. But, they said in the case, the gift of a horse or a hawk or a robe, etc., in satisfaction is good. So, clearly, as we'll see, if you're giving something else, it may very well be okay. But if it is less, or a figure less than it should be, so it will not be allowed. So, as I say, they said the gift of a horse or a hawk or a robe in satisfaction is good, as more beneficial to the plaintiff than the money. The rule is, of course, obiter, because in Pinnell's case itself, the debt was paid before the date of satisfaction, which was considered good consideration. The decision, though, was applied by the House of Lords in the case of Folks and Beer to another part payment of a debt situation. Now, are there ever any circumstances where a person could pay less and it extinguishes the whole? So, put another way, are there exceptions to Pinnell's case? Well, if the original sum was unliquidated and it was disputed in good faith, or the payment was made at the creditor request at an earlier time, or at a different place, or by a different method, then, but please bear in mind that paying by check versus cash is not a different method, or by a third party, then those will amount to good consideration sufficient to discharge the whole. And the third party situation, of course, is the Hirachan and Punachan and Temple case. Now, if it is that you see a situation where somebody has paid in a different place and a different time, please bear in mind that the one requirement that needs to be there is that the creditor has requested it. It can't be that I decide that I owe you money in Birmingham and I then paid to you in London and say, well, I've paid you part of it now and I paid it to you in a different place. It must, of course, be at my request. Now, the doctrine of promissory estoppel moving forward, under certain circumstances, stops a promisor from going back on his promise to accept a smaller sum in discharge of a larger sum. Now, the doctrine of promissory estoppel was first developed in the House of Lords decision in Hughes and Metropolitan Railway, but it was pretty much dormant for a while until we see a revival by Lord Justice Denning, of course, in the High Trees case. And what we see is that Central London Property and High Trees is now the somewhat seminal case in respect of promissory estoppel, but the reality is that its life started in Hughes and Metropolitan Railway. Now, in Hughes, Thomas Hughes owned property leased to the railway company, and under the lease, Hughes was entitled to compel the tenant to repair the building within 6 months of notice. Now, notice was given from which the tenant had until a certain time to finish the repairs. The tenant, was a railway company, sent a letter proposing to purchase the building from Hughes. Now, negotiations began and continued, but nothing was settled. Once the 6 months had elapsed, the landlord sued the tenant for breach of contract and tried to evict him. Now, the House of Lords in the case affirmed what the Court of Appeal had found below, and it ruled that with the initiation of the negotiations, there was an implied promise by the landlord not to enforce their strict legal rights with respect to the time limit on the repairs, and the tenant acted on this promise clearly to their detriment. So the idea coming out of Hughes is that if you lead me to believe something and then I act on that, then you cannot stand on your strict legal rights. Well, in this case, the plaintiffs leased a block of flats to the defendant at an annual rent of £2,500. But because the defendants were unable to find enough tenants while London was busily being bombed during World War II, they agreed to accept a reduction in rent of £1,250. Now, there was no consideration for this promise to accept a lower rent. At the end of the war, the flats were again fully let. So basically, it was practically a ghost town. And they said, look, if you stay on board, we're going to charge you less. And they did. But after the war, things started picking up and the block was fully let. The plaintiffs claimed the full rent for the remainder of the contract beginning the final half of 1945, so after the war. Now, the interesting thing about High Trees is, again, like so many cases in English law, it is the obituary marks which then come to stand for the principle in the case. Because in the case itself, they were not looking for payment during the war years. They were looking for payment after the war. Now, Justice Denning said that in good conscience, they were entitled to the full rent from the end of the war. But he noted, and this is where the doctrine arises, he noted, obiter, that they were stopped from going back on their promise had they claimed rents from the wartime period as well. Now, promissory estoppel requires that there be an unequivocal promise by words or conduct, and evidence that there is a change in position of the promisee as a result of the promise, reliance, but as I say, reliance, but it's not necessarily to their detriment. It just said that they have relied on the promise. Now, in general, if you meet the requirements, and it would be inequitable for the promisee to go back on the promise, the courts will certainly find that you can rely on promissory estoppel. The thing with promissory estoppel, though, it is that it is what is termed able to be used as a shield, not a sword, in that it cannot be used as the basis of a cause of action on its own. It also does not apparently extinguish rights, so you still have rights that you previously had. Now, in High Trees, the plaintiff company was able to restore payment of full rent from early 1945 and could have restored the full rent at any time after the initial promise was made, provided a suitable period of notice had been given. And in the case, the estoppel was applied to a negative promise. That is, one where a party promises not to enforce his full rights. Now, estoppel is an equitable construct. It is not of the common law, and the application is therefore discretionary. It is going to mean, of course, that if you come to equity, you must come with clean hands, and all of the other equitable maxims will apply. So look clearly at what the examiner is asking, because if, for example, the examiner says to you that a particular person, so I ask you to do some work on my house, we've agreed, and the fact of the matter is that I'm supposed to pay you 5,000, but at the end I only pay you 4, and you took the 4 thinking, oh, okay, it's all right, I'll probably get work from her, and you said, okay, are you stopped from going back on the promise? And the fact of the matter is, if you have done something to lead me to believe that it was okay, which equity would frown upon, then it may be that I would get my way. But if there's nothing to suggest anything other than that, well, the only money I have right now is £4,000 and I give it to you, that may not be sufficient to say that you could not bring an action in respect of part payment, and certainly promissory estoppel would not help me in the circumstances. So when you consider this area, there are some other cases that you can look at, particularly with this shield, not a sword. Certainly the case of Combe and Combe, very important, because again, we see Lord Justice Denning elaborating in that case as to the equitable nature of estoppel and refusing to allow it to be used as a sword. And in that case, it was where an ex-wife sought to extract funds from an apparently destitute husband. Now, here is a question. Do you think that there is a place for promissory estoppel in light of Williams and Ruffy? Now, I want you to think about this for a minute, because it may not be something you've previously thought about. What we saw in Williams and Ruffy was a situation where you already owed a duty, but the court said it's fine. You can use it in order to get, as further consideration. What if I say to you, why shouldn't there be a similar situation when you look at the concept of promissory estoppel? Because when you look at Williams and Ruffy, you're getting paid more for the same. But when you look at promissory estoppel, isn't there the argument that you are coming from the standpoint of paying less for what was originally agreed? Well, it is true that the broader view of consideration is likely to reduce the need to use promissory estoppel, though it is still not possible to, of course, be sure how far Williams and Ruffy's development will, of course, go in respect of promissory estoppel. The courts did have a look at it in Reselect Move, and they did, of course, say, and they did consider it. They said Williams and Ruffy had not affected the rule in Folks and Beer. So as far as they were concerned, there was not a similar situation in the context of promissory estoppel. So here we're saying, for example, go back to the situation where we're looking at Williams and Ruffy. I contract you to build a shed for £1,000. Let's say £800. I come back and I offer you 1,000. I have just now paid more for the same. But look at it where, let's say that we had agreed at £1,000, but I've come and I've offered you 800, because maybe you thought you would, for example, get more work from me. So you did think that there was something that might come out of it. Couldn't that thought of yours being that you would get more work from me, could that stand in the same way as some kind of practical benefit? Well, as I say, it has not gone down that route, but it is the kind of academic train of thought that I would ask you to pursue when you think of that area. That, of course, brings us to the end of consideration, and certainly the next session that we will consider in order is, of course, terms and not only the certainty of terms, but looking at terms of a contract generally.